This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
It's a little bit lengthy judgment. I will be reading only the relevant portions. The West Bengal Central School Service Commission, hereinafter referred to as the Commission in short, by a notification bearing number such and such dated December 16, 2016, had announced the state-level selection test for recruitment of assistant teachers in physical education and work education in recognized non-government aided sponsored schools in West Bengal, hereinafter referred to as the first SLST 2016 in short. The petitioners of this batch of writ petitions had participated in the said selection test but were unsuccessful. The petitioners are challenging the said selection process on the grounds that it is vitiated by corruption and malpractices of the respondent authorities. They are also challenging the legality and validity of the order of the School Education Department Secondary Branch, Government of West Bengal, bearing number such and such dated May 19, 2022, so far as it relates to creation of 1600 supernumerary posts of assistant teachers with breakup of 750 posts of work education and 850 posts of physical education teachers. To appoint all waitlisted candidates of the said first SLST 2016 under the said two categories, and the notices bearing number such and such dated October 14, 2022, whereby the Commission had notified the dates of counseling for filling up the said supernumerary post. In order to afford opportunity of being heard, the said waitlisted candidates were notified. Some of them had applied for their addition in one of the writ petitions, being WPA 25056 of 2022, except one being CAN 11 of 2025, which was not moved. All applications were allowed. In consequence, the applicants of those applications have been added as respondent number 7 to 301 in the said writ petition. The legality and propriety of first SLST 2016 and the said two notifications are under challenge in the writ petition. The added respondents in terms of the said notification dated May 19, 2022 have already recommended for appointment long back, but could not be appointed due to the interim order of stay passed in one of the writ petitions. Therefore, there is an imminent urgency in deciding the challenge to the said notification dated May 19, 2022 and October 14, 2022. As such, the said challenge is taken up for consideration independently first, keeping the other dispute issues raised in the writ petition pending. The state and the added respondent at the threshold have raised an objection as to the locus standi of the petitioners to maintain the writ petitions, particularly to throw challenge to the said notification dated May 19, 2022 and October 14, 2022, as the petitioners are unsuccessful candidates of first SLST 2016. Therefore, the first issue falls for consideration in the matter is thus whether the petitioners, being unsuccessful candidates of relevant selection tests, are entitled to challenge the notification dated May 19, 2022, and whether such challenge is barred by limitation. The issue being related to maintainability of the writ petitions, the respondent have the right to begin. The argument of the learned counsel for the parties to the on the said issue are recorded herein below in seriatim. Now the argument of is starting from this respondent's argument, Mr. Sengupta onwards. I have recorded the submissions of all parties. Then Mr. Vikas Ranjan Bhattacharya, petitioner. The next issue, I have the second issue, calls for consideration is as follows. Whether the creation of supernumerary posts to give appointment to the Westlists candidates of the panel of first SLST 2016 in the post of assistant teacher for the subject work education and physical education in upper primary level of school is legally sustainable. Then again, according to the argument of the learned counsel for the parties, on the second issue are recorded herein below in order of their appearance. Now, the court on first issue. The Honorable Supreme Court in the case of Dharanidhar Mishra Supra, cited on behalf of the petitioners, has observed that in a case where the demand for justice is so compelling, a constitutional court would exercise its jurisdiction with a view to promote justice and not to defeat it. Keeping the said object in view, the issue of maintainability is addressed. The decision of learned single judge of this court in the case of Ganesh Chandra Mukherjee, cited on behalf of the respondent, is completely irrelevant to decide the issue, inasmuch as in the said decision objection was taken as to the jurisdiction of the court to maintain an application under Article 226 of the Constitution of India Constitution against a company, which such is not a challenge here. I am at one with Mr. Bhattacharya that to decide the issue of maintainability of writ petitions raised by the respondents, the averments made in the writ petition must be taken to be true and correct. If the said test is applied, the issue of maintainability vis-a-vis the locus standi of the petitioner cannot be decided at the threshold as a preliminary issue. The Honorable Division Bench in MAT 723 of 2025, while affirming the order of injunction passed by this court, had never directed the said issue is required to be heard first, deferring the decision on merit. Therefore, I am unable to convince myself to accept the argument of Mr. Sengupta that the issue of maintainability should be decided as a preliminary issue, particularly when the said issue raises a mixed question of law and fact. To answer the issue under consideration, it is necessary to understand the scope of present writ petitions. The petitioners are challenging the legality and validity of the entire first SLST 2016 so far as it relates to the recruitment of assistant teachers at the upper primary level of recognized non-government aided sponsored schools in West Bengal for the subject physical education and work education on the grounds that the said selection test is initiated by malpractices, illegal actions, and manipulation of the respondent authorities. The petitioners, though, have participated in the said selection test but were unsuccessful. As such, their locus to maintain this said challenge is questioned. There was another recruitment drive conducted by the Commission in the year 2016 for recruitment of assistant teachers for class 9, 10, 11, 12, Group C, Group D post. In several writ petitions, the said selection test was challenged on the self-same grounds of fraud, illegality, and malpractices of the authorities. The challenge was sustained. As a consequence, the entire selection process was set aside by the Honorable Division Bench of this court in the case of Boishakhi Bhattacharya. The said decision was affirmed by the Honorable Supreme Court. In the backdrop of such facts and circumstances, it will not be just and proper to dismiss the writ petition at the threshold on the ground of maintainability without verifying the veracity of the allegations made therein. The petitioners are alleging the fresh vacancies have been created in the name of supernumerary courts. As such, all participants in the said relevant selection test have a right to be considered against those vacancies. The allegation needs to be investigated on merit, and without such step being taken, the writ petitions cannot be dismissed on the ground that the petitioners being unsuccessful in the relevant selection test have no locus standi to maintain the writ petitions. The Honorable Division Bench of this court in the case of Boishaki Chatterjee, while overruling the similar objection, had observed at paragraph 163 that writ petitioners are participants of the selection process, albeit unsuccessful by most, but they are entitled to fair consideration in the selection process. The said paragraph is quoted below for ready reference. Then 163 quoted. The Honorable Supreme Court in Vidya Devi versus State of Himachal and others reported in 2022 Supreme Court cases 569 has held that delay and laches cannot be raised in a case of continuing cause of action or where the facts shock the judicial conscience of the court. Moreover, there is no period of limitation for courts to exercise constitutional jurisdiction to do substantial justice. The action complained of shocks the judicial conscience of this court, inasmuch as the state, by the impugned notification, has sought to inject life into a dead panel. Such action of the state is not legally sustainable. The present context demands consideration of paragraph 147 of the decision of the Honorable Division Bench in the case of Boishaki Bhattacharya. 147 quoted, no appointment can be made after expiry of the panel, as the panel is not a perennial reservoir for appointments. Panel is valid for the declared vacancy and for the specific period. Appointment towards future vacancies cannot be made from the panel. Appointments made in violation of Article 14 and 16 of the Constitution of India are a nullity. Courts have no jurisdiction to direct appointment to be made beyond the validity period of panel. Therefore, in the facts and circumstances of the present case, the alleged delay and laches are no fetter to maintain the present challenges. The decision cited on behalf of the respondent in the case of Aflatun and others versus Chennai Metropolitan Corporation in Murugeshwan are therefore factually distinguishable. The petitioners had participated in the relevant selection test, though unsuccessful, but they cannot be said to be totally strangers to the said selection process. In view of the nature of allegation and relief claimed in the writ petitions, the petitioners cannot be thrown overboard on the allegation of not having locus standi without addressing the said allegation on merit. In view thereof, the proposition of law laid down in the following decision on the point of locus standi to maintain writ petition cited on by the respondents in the case of Ayub Khan, Tridevi, Himanshu, Gyan Shabhai, Tajbir Singh, etc. are not applicable in the present case, inasmuch as in all those decisions, the Honorable Supreme Court had decided the said issue upon consideration of the cases on merit. In case of Bombay Dyeing, Supra, and in case of Taibai, the issue was relating to the grant of an order of injunction and the maintainability of the lease, which is not the issue under consideration. Therefore, the said decisions are not relevant to the context. In the case of Chandrakanto Ganguly, the Honorable Division Bench of this court has held that when executive action of the state is challenged, the court must tread with caution and should not overstep its limit, but with the further observation that the court is warranted only then when there is oblique motives and miscarriage of justice. Petitioners have alleged both. It has already been held that the step taken by the state to give life to an expired panel prima facie is not legally justifiable. Therefore, the said decision cited on behalf of the respondent is of no help to them. It is not the validity of the decision, but the validity of the decision-making process to create superintendent post is under challenge. Therefore, the said challenge is open to judicial review. The premise of the challenge being different on the decision of the Honorable Division Bench of Delhi High Court in the case of S.S. Goel is not applicable in the present case. In view of the above discussion, the first issue was answered affirmative. The petitioners have locus standi to maintain the writ petitions and are entitled to challenge the notification dated May 19, 2022 and October 14, 2022. The court on the second issue. The Government of West Bengal Education Department Secondary Branch by a notification dated September 20, 2016 had framed the rules regulating the manner and scope of selection of person for appointment to the post of teachers for upper primary level of schools, namely the West Bengal School Service Commission selection for appointment to the post of teachers for upper primary level of school rules 2016, hereinafter referred to as the said rules of 2016 in short. The commission, being designated by the said rules of 2016, had notified first state level selection test, the first SLST 2016 in short, for recruitment of assistant teachers in physical education and work education in recognized non-government aided sponsored school in West Bengal, wide notification bearing number such and such dated December 16, 2016 against the vacancies available under the said rules of 2016. The relevant portion of the said recruitment notification dated December 16 is quoted below for ready reference. Emphasis has been supplied against vacancies available under the West Bengal School Service Commission selection for appointment to the post of teachers for upper primary level of school rules 2016. The said rules of 2016 prescribes a complete mechanism for selection of persons for appointment to post of teachers for upper primary level of schools. The Rule 8 thereof lays down the procedure as to how the vacancies for such recruitment process would be ascertained. The said rule prescribes that the district inspector of schools, on being asked by the director of school education, shall prepare a report regarding the number of vacancies in posts and shall send it to the director of school education. The said director, on receipt of such report with due approval from state government, shall send it to the central commission. Firstly, before the date of publication of advertisement, before inviting application. Lastly, 15 days from the date of publication of the result of the written examination or interview list, as the case may be. The relevant portion of Rule 8 of said rules of 2016 is quoted below. Then Rule 8 is quoted. Rule 16 of the said rules of 2016, apart from mandating that each panel and waiting list shall remain valid for 1 year from the date of publication of the panel and waiting list, or the date of advertisement for the next recruitment process, whichever is earlier, by virtue of the proviso thereof, also stipulates that the names of candidates shall not be recommended against any post other than the post applied for, or against any vacancy which has not been notified in terms of sub-rule 3B of the Rule 8 of said rules of 2016. Relevant portion of the Rule 16 of the said rules of 2016 is quoted below. Clause 11 of the recruitment notification dated December 16, 2016 reiterates the said mandate of the said rules of 2016. The same is also quoted below. The position of extant rule, as it appears from the above discussion, is that the recruitment drive was initiated to fill up the vacancies available under the said rules of 2016. The Rule 8.3 thereof fixes the time limit within which such vacancies are required to be ascertained and reported to the Commission, but the said procedures were not followed in creating the vacancies for the waitlisted candidates of first SLST 2016. The state has created the said vacancies in the name of supernumerary post with the approval of the committee. The petitioners in WPA 25056 of 2022, by way of supplementary affidavit, have brought the cabinet memorandum bearing number such and such dated May 5, 2022 on record. The Principal Secretary of the Government of West Bengal School Education Department, by the said memorandum, inter alia had proposed to create 1600 supernumerary posts with breakout of 750 and 850 for absorption of all waitlisted candidates of first SLST 2016. To understand how the said vacancies in the name of supernumerary posts were proposed to be created, the said cabinet memorandum dated May 5, 2022 demands a close look. The said memorandum records the proposal of the Central School Service Commission for creation of 5,261 posts. The relevant portion of the said proposal is reproduced below. Then it is reproduced. The said memorandum thereafter records the proposal of the Commissioner of School Education to create 1600 supernumerary posts, breakup of 750 and 850. To absorb all waitlisted candidates of physical and work education subject to validation of panel. The relevant portion of the said proposal is reproduced below. The following views of the School Education Department of the West Bengal Education Department, Government of West Bengal on the said proposal are recorded in the said memorandum. Then what was their proposal? The no objection of the Finance Department has been recorded in the said memorandum, which was subject to the approval of Cabinet and adherence to the extant rules. The said memorandum ultimately records the proposal of the Department of School Education to create supernumerary posts. The said proposal is reproduced below for ready reference. It is clear from the above discussion that the aforesaid vacancies in the name of supernumerary posts have been created without following the said rules of 2016, particularly Rule 8 thereof. As such, the said vacancies are apparently new vacancies. Consequently, it cannot be exploited to give appointment to the waitlisted candidate of the panel of first SLST 2016, inasmuch as proviso appended to Rule 16 of the said rules clearly stipulates the names of candidates shall not be recommended against any vacancy which has not been notified in terms of Sub-Rule 3B of Rule 8 of said rules of 2016. The Honorable Division Bench of this Court in the judgment dated April 22, 2024, passed in Boishaki Bhattacharya Supra, had directed the CBI to undertake further investigation with regard to the persons involved in the state government approving creation of supernumerary posts to accommodate illegal appointments. If necessary, shall undertake custodial interrogation of such person involved. The Honorable Supreme Court, in its order dated April 8, 2025, passed in Civil Appeal number 4800 of 2025, arising out of the said judgment of the Honorable Division Bench, had set aside the said direction for investigation into creation of supernumerary post, with a clarification that the observation and direction made in the said order are limited to the extent of such direction of the Honorable Division. The relevant portion of the said order of the Honorable Division Bench is quoted below. This is the Supreme Court. Is quoted below. The Honorable Supreme Court, by the said order dated April 8, 2025, had never put a restriction to look into the legality and propriety of the creation of such supernumerary posts. Therefore, the present challenge is no way affected by the said order. The state has sought to justify the creation of the said vacancies in the name of supernumerary posts on the ground the state is obliged to fulfill the constitutional mandate of Article 21, capital A, to provide free and compulsory education to all children of the age 6 to 14 years, and to follow up legislation, the Right to Education Act 2009, puts the state under the obligation to provide adequate number of teachers to the schools. As such, it has taken a decision to create supernumerary posts to absorb the waitlisted candidates of first SLST 2016 to meet a special exigency. The same being a policy decision is not open to judicial review. The said justification is not tenable inasmuch as it is a settled position of law that policy decision is not open to is open to judicial review if it is found to be arbitrary, unconstitutional, and in violation of the statutory provision. Of course, cautious approach is needed when such policy is based on cabinet decision, as has been held by the Honorable Supreme Court in the case of Himachal Pradesh Niji Vishayak Parishan Kendra Sangha Supra, cited by Mr. Kalnan Bandyopadhyay, learned senior advocate for the respondent number 289 to 301. However, in the present case, even if the said test is applied, this court cannot foreclose its jurisdiction of judicial review under Article 226 of the Constitution, as the decision is arbitrary and in complete violation of the extant rules. In the backdrop of the decision cited by the learned Advocate General in the case of Bhikari Charan Kuntia, Pushpa Rani, official liquidator, and Lieutenant CDR M. Ramesh are of no help to the state. In this context, the observation of the Honorable Supreme Court in the case of Manohar Lal Sharma at paragraph 14 being relevant are quoted below. On matters affecting policy, this court does not interfere unless the policy is unconstitutional or contrary to the statutory provision or arbitrary or irrational or in abuse of power. The Honorable Supreme Court in the case of BP Singhal and SR Mumbai has held that though no reason to be assigned for the discontinuance of the pleasure resulting in removal of governor, but even then the power under Article 156(1) of the Constitution is open to judicial review if such power is exercised in an arbitrary, capricious, and unreasonable manner. No doubt the state has the obligation to achieve the constitutional mandate enshrined under Article 21A, but to get it, the state cannot compromise with the rules and regulation framed to regulate the appointments of the teachers. In the present case, such compromise has been made to give appointments to the waitlisted candidates of an expired panel. The argument of the learned Advocate General that a discretion can be exercised for creation of supernumerary posts to promote the object and purpose of 21A of the Constitution, Article 21A of the Constitution, without taking recourse to a fresh selection process cannot be accepted for the reason that such discretion has been exercised in an arbitrary manner in violation of the relevant rules. The vacancies so created in the name of supernumerary posts, since are new vacancies, those are required to be filled up in the new selection process. The petitioners, being eligible, had participated in the first SLST 2016 but could not qualify. However, with their such eligibility, they are subject to age bar, entitled to participate in the next selection process to offer themselves against those new vacancies. But the petitioners, in view of the decision of the state to exploit the said vacancies to accommodate the said waitlisted candidates of the earlier selection test, that is first SLST 2016, have lost the said opportunity. The said decision, therefore, certainly offends the constitutional schemes of Article 14 and 16. The Honorable Supreme Court in the case of Raj Kishore Nanda has held that it is settled legal position the vacancies cannot be filled up over and above the number of vacancies advertised, as the recruitment of the candidates in excess of the notified vacancy is a denial and deprivation of the constitutional right under Article 14, read with Article 16(1) of the Constitution, of those persons who acquired eligibility for the post in question in accordance with the statutory rules subsequent to the date of notification of the vacancy. In this backdrop, the argument of the respondent that the petitioners being unsuccessful and waitlisted candidates being successful, the waitlisted candidates being successful in the first SLST 2016 are wholly different classes. As such, there is no infringement of Article 14 of the Constitution is misconceived. Therefore, the challenge to the locus standi of the petitioner to maintain the writ petition and to throw challenge to the impugned notices is overruled. The creation of vacancies in the name of supernumerary posts have been sought to be justified from another angle, that is, state in exercise of its executive power vested in it under Article 162 of the Constitution can create such vacancies. The said justification is not tenable in as much as the executive powers so vested are subject to other provisions of the Constitution. In other words, executive powers cannot be exercised to defeat the right to equality guaranteed under Articles 14 and 16 of the Constitution. The decision of the Honorable Supreme Court in Rai Sahib Ram Jaya Kapoor and the decision of the Honorable Division Bench Sharad Kumar Singh have explained the scope of executive power under Article 162 of the Constitution. There is no dispute that executive power of the state shall extend to the matters with respect of which to which the legislature of the state has power to make laws, but exercise of such power is not immune from judicial review when it is done arbitrarily, capriciously, or unreasonably. The decision of the Honorable Supreme Court in the case of Samser Singh and Hurinath, cited by learned Advocate General, is on the issue regarding extent of power of governor in conducting the business of the government under Article 166(3) of the Constitution, but the issue is nowhere connected with the present issues under consideration. The Cabinet Memorandum dated May 5, 2022 has recorded grievances of the candidates in the recruitment process of first SLST 2016, which inter alia indicates that the proposal of creation of such vacancies was to instill confidence in general public in the matters pertaining to education and involving public environment. It is rightly submitted by Mr. Bhattacharya, a senior counsel for the petitioner, that constitutional morality must prevail and cannot be replaced by political morality. Paragraph 146 of the decision of the Honorable Supreme Court in the case of Srinath Balasaheb Patil being relevant to the contest is quoted below. Contention of the respondent that the political exigencies required such measures to be taken needs to be rejected. The constitutional silences cannot be used to introduce changes of such nature. The Honorable Supreme Court in Chandan Banerjee has noted the following definition of term supernumerary post from Oxford English Dictionary: present in excess of the normal or requisite number, or not belonging to a regular staff but engaged for extra work. A supernumerary post is defined a post exceeding the usual stated or prescribed number. There is no dispute with regard to the nature of supernumerary post. A supernumerary post is a temporary additional position created for a limited time to accommodate an employee when a regular post is not available. The Cabinet has approved the proposal as contained in a Cabinet memo dated May 5, 2022 to absorb waitlisted candidates of first SLST 2016 in the vacancies created in the name of supernumerary post. Therefore, conceptually, the supernumerary post is a post to be created to absorb an existing employee when such employee could not be accommodated in a regular post. There is no dispute with regard to the proposition of letdown in the case of Horen Borgian, cited by Mr. Kalyan Bandyopadhyay, that supernumerary post denotes creation of temporary post outside the cadre personal to the incumbent. However, the said decision is of no help to the respondents. Decision cited by the learned Advocate General in the case of Pushpa Rani to contain the supernumerary post created at the same time in different cadres can also be constitute part of the cadre is completely irrelevant to the present issue. The waitlisted candidates of first SLST 2016 were not in employment. In fact, the panel and waitlist of the said selection test had expired long before the Cabinet approval of the proposal of creation of supernumerary post in the name of vacancies in the name of supernumerary post to accommodate the said waitlisted candidate. Interestingly, Finance Department, Government of West Bengal granted its no objection to the proposals to absorb, quote unquote, absorb the waitlisted candidates subject to the validation of panel. The cabinet was aware about the position that the supernumerary post cannot be created to appoint a person. As such, consciously used the word to absorb in the cabinet memorandum dated May 5, 2022. The Honorable Supreme Court in Devdotto Supra has held that the term absorbed in service jurisprudence with reference to the post implies that an employee who has not been holding a particular post in his own right by virtue of another recruitment or promotion to that post but is holding different post in a different department is brought to this post either on deputation or by transfer and is subsequently absorbed in the post with whereafter he becomes a holder of that post in his own right and loses lien on the present post. Summing up the discussion made above, I am of the opinion that supernumerary post cannot be created to appoint the waitlisted candidates of first SLST 2016 for the subjects work education and physical education. In terms of the Rule 2013, the panel of first SLST 2016 was remained valid for 1 year from the date of publication of the panel of the waiting list or date of advertisement of the next recruitment, whichever is earlier. The recruitment notification dated December 16, 2016 also stipulated the same time limit for the life of the said panel. The panel has admittedly expired on December 11, 2019, long prior to the date of cabinet approval of the proposal of the School Education Department to create vacancies in the name of supernumerary post to accommodate the waitlisted candidates of the said expired panel. The Honorable Supreme Court in the case of B. Valluvan has held the life of panel, as is well known, must be for a limited period. It is governed by the statutory rules. The following extracts of paragraph 9 of the decision of the Honorable Supreme Court in the Jagadish Chopra being relevant is quoted below. Then paragraph 9 quoted, the decision of the Honorable Supreme Court in the case of A.P. Agarwal cited by the learned Advocate General is completely misplaced in the facts and circumstances of the present case, inasmuch as in the said case the validity of the panel was not extended. Rather, the second candidate of the panel was appointed in terms of the office memorandum as the vacancy had occurred due to the resignation of the first candidate within 6 months of joining. The order of the court cited on behalf of the state is of no help to the respondent. Rather, it supports the case of the petitioners inasmuch as in the said case, this court had dismissed the writ petition, accepting the submission made on behalf of the commission. The panel has expired long back. In the case of Gujarat State Deputy Executive Engineer Association, Supra, the Honorable Supreme Court has explained that a waiting list is in the present case. There is no issue on the what the waiting list is. In the present case, there is no issue on the validity of the waiting list. Therefore, the said case has no manner of application. It is settled position of law. Waiting list cannot be treated a perpetual reservoir for filling up the future vacancies. The argument of the respondent that the life of the panel stood extended due to the pendency of the litigation in respect of first SLST 2016 is completely unacceptable, inasmuch as the selection process was conducted in terms of a statutory rule. The decision of the learned single judge of the Rajasthan High Court on behalf cited on behalf of the respondent number 289 to 301 in the case of Ram Babu Kohli on this point is factually distinguishable. The Honorable Supreme Court in Sulekha Chandra has specifically held the appointment divorced these statutory rules is void ab initio. That being the position, I am unable to accept the argument of Mr. Sengupta that supernumerary posts have been created as a gap-filling measure since first SLST 2016 is governed by a statutory rule. Therefore, on this court, the judgment of the Honorable Supreme Court in the case of Kantri Ravi cited on top of the respondent number 7 to 207 is of no help to the said respondent. The decision of the learned single judge of this court in Saroj Karmagal is no pointer to the issue under consideration. Argument of Dr. Patro that the substantive post cannot be equated with the supernumerary post. As such, the rules of 2016 is not applicable in respect of the post created by impugned notification is completely fallacious in as much as the waiting list is in relation to first SLST 2016, a selection test governed by a statutory rule, that is said rules of 2016. The Honorable Division Bench of this court in Rajiv Brahma has dealt with first SLST 2016 for recruitment of assistant teachers in upper primary except physical and work education in government schools. Therefore, the said decision has got no manner of application in the present case. Conclusion: in view of the discussion made above, the impugned notices being dated 19 May 2022 and 14th October 2022 are set aside and quashed. The connected application can 11 is dismissed. There shall be no order as to court. Let the writ petition listed in monthly combined list of January 2026 for considering disposal of other issues involved in the writ petition. Black pen, black pen. এই ঝোলাতেও পারে সত্যি দর্শনীয়, এটাই আনেন। এটা দিয়ে দেবেন, আর কারেকশন আছে কতগুলো, ফার্মে ঢুকান, পরে দেখবে যে এই লাইভ বন্ধ করো।